Here we are, less than 24 hours, I guess, right, from the Supreme Court coming out with a ruling striking down the vaccine mandate issued by President Joseph R. Biden for private sector workers employed by companies with more than 100 employees. On the other hand, sustaining the mandate for healthcare workers who work for institutions that participate in government programs such as Medicare and Medicaid, specifically Medicare and Medicaid, right?
Yes.
CMS.
Yes, if you work for a provider of healthcare services that's getting paid through a program administered by CMS, you should assume you're covered.
Okay. So break this thing down for us. The vote, I believe, on the private sector mandate was 6-3 on somewhat partisan lines in terms of who appointed, Republican or Democrat, those justices. That's correct?
Yes, I guessed that one correctly. The more interesting break was between the judges who went all the way to question the constitutionality of the statute, Gorsuch, Thomas, and Alito, and the judges who stopped short of that.
Okay.
Kavanaugh, Barrett, Roberts.
Interesting. So a little surprised at the sustaining of the CMS mandate, and that's where Kavanaugh and Roberts broke, right? It's what we're saying here, and sided with the liberal-leaning justices.
Yes, for the moment. By the way, neither one of these decisions is a final decision on either of the mandates. Both of them were answering a narrow procedural question. In the OSHA case, it's whether or not the stay that was overturned by the Sixth Circuit should be reimposed pending final outcome. In the CMS case, it was whether we should overturn the stay that's been imposed below pending the final outcome.
Okay.
So the result is getting all the way to the end of this. I don't see any way forward for OSHA to enforce this rule, even though that was not a final ruling. The 6 judges who agreed to strike enforcement currently wrote their opinion in such broad terms. I don't think OSHA can get around it by readopting the rule as an Administrative Procedure Act final rule. I just don't see any way forward for OSHA. I think the result is going to be the same below. And I think Marty Walsh's tweet, Secretary of Labor Marty Walsh's tweet yesterday afternoon, which I interpreted to be quite angry, corroborated that for me.
You want to recite that for us? You sent it to me, and I read it, and it's like, this guy ain't happy.
Let me read the last few words.
Yeah,
and I'm quoting, quote, "Regardless of the ultimate outcome of these proceedings, OSHA will do everything in its existing authority to hold businesses accountable for protecting workers, including under the COVID-19 National Emphasis Program and the General Duty Clause." Now, I take that to be a finger wagging saying, well, we can't enforce this rule, but you have a general duty, employers, to keep your employees safe from recognized hazards in the workplace. And to the extent we can, we're going to enforce this rule under the General Duty Clause. Now, if it was a stretch to enforce a rule that's specific, it's a much longer stretch to enforce the same rule under a General Duty Clause that's much more vague.
Yeah.
I don't think that's going to fly ultimately either.
Yeah.
I think the challengers have a little bit better shot reversing the outcome below on the CMS mandate. They at least have a couple of things to argue that the Supreme Court didn't foreclose for them. One is the question of how to apply the statute that says that CMS has no authority to control conditions in terms of employment.
Okay.
The dissent spent a paragraph on that. The majority didn't say anything about that. So I think that's an open question below. Also, the majority leaned heavily on some statutes that expressly allow CMS to impose infectious controls measures on providers.
Okay.
But those statutes, there are a bunch of them, don't have the same language with regard to every type of provider. Hospitals has one statute, ambulatory surgical clinics, nursing homes. There might be a way to slice and dice the people who are challenging this in a way that it might not apply to you because of the difference in statutory language. Now, again, I'd rather be on CMS's end of those rulings than on the challengers' rulings, but I don't think it's hopeless for the challengers below.
Interesting. So a couple of things come to mind. First is, and I'll ask both questions first and then let you respond. what in the world is an employer supposed to do? And I know your job is to advise employers, but it sounds still a little squishy, and it sounds like OSHA has got their sights set on trying to work around this ruling and find other ways to impose and I guess fine within their scope of authority employers for not having their folks vaccinated. But the other thing that comes to mind, all kinds of revelations now, certainly in the last month or so with Omicron, that vaccinated people can still spread. They can contract. It is argued that much less serious symptoms and disease, but they can also spread. So how can you say that by being vaccinated you're protecting the workplace if you're still shedding virus and can infect other people?
You know, probably you ought to have a doctor or epidemiologist on to talk about that. I'm just a lawyer, and I can tell you that politics and law always is lagging behind the facts.
Okay. But lawyers are going to seek expert testimony, I got to believe, from epidemiologists that say, well, yeah, because I keep wondering that, well, who are we protecting here exactly? Protecting the people who aren't.
We protected a lot of small businesses who ought to be having pizza parties today. In fact, what I'm telling my clients is, don't assume your employees know that the law has changed and you don't have to fire them anymore.
Okay.
They may be quitting next week because they think you're about to have to fire them. Make sure they know that the law has changed and you are no longer under obligation to fire them if they won't mask and test or vaccinate.
Good point.
So you don't lose any more people than absolutely necessary.
Okay.
And then go have a pizza party.
So your advice to employers is make sure everybody's updated.
Make sure they know.
Okay,
yes.
I understand. But is there anything they should do just to kind of be on standby or poised or staged in case they come up with some way to usurp this deal and come out? Is there anything they can do?
A lot of those people are also federal contractors, and that's where my concern would be. In fact, as soon as I get out of here, that's where my research is going. I'm going to go read all the briefs and all the federal contractor cases. There are 2 cases in courts of appeal right now, the 11th Circuit and the 6th Circuits. If I were one of those judges, I'd be asking for rebriefing of the issues now that we have the Supreme Court opinions. I can imagine that the government is going to say that the CMS case, because it's about the authority of the government as purchaser to regulate, controls the federal contractor case because, again, it's about the authority of the government as purchaser to regulate. I don't know if that's a winning argument or not. I need to know more before I pronounce on that.
Yeah, so it sounds to me like, I guess the fundamental question is, can the government, as an acquirer, can it stipulate certain requirements of its vendors and certain conditions be met by its vendors? I mean, that's common. As a vendor, I'm pretty familiar with that, and they can be extensive.
Yes.
But I guess the question is, does requiring vaccinations rise to the level of being reasonable in terms of a condition? I don't know. That's a complicated legal question.
Well, yes, and it's a narrower question than the one that got Justice Roberts' attention, which is, should we analyze this narrowly, or should we look at this as the United States government trying to exercise a general police power over the population, which the Constitution does not give the United States government?
Okay, gotcha. All right, so... Wow, it was. So, what's the status, by the way, of the federal contractor mandate? That's in a different situation than these two. It's what?
It's currently blocked
across the nation, all districts.
Yes. Well, because of district court rulings, it's blocked nationwide.
Okay.
Except in federal buildings and on federal facilities. So, if you're working in a federal building or a federally controlled facility, it may still apply to you.
Oh my gosh, this is so crazy. You want to hang around and talk about this some more? Because I think there's some other questions that employers may have about how to deal with this, and I know that's your specialty and area of expertise. We got Pepper Crutcher. He's an attorney at Balch & Bingham. We're talking about the SCOTUS rulings on the vaccine mandates. Not a good day for the president on that front. Stay with us. Pepper Crutcher, attorney, Balch & Bingham, longtime counsel of my old company and an expert in all things employment and labor law. We're just talking about the vaccine mandates. All right, so your thoughts on why Justices Gorsuch and Roberts, went in the other direction on the CMS, the healthcare workers mandate, sustaining that one, but voting against and to strike down the private sector mandate.
Like what we were discussing off air, you remember the line from The Hunt for Red October by Kevin Spacey, who is the presidential assistant, who said two things about politicians: we kiss babies and we leave our options open. I think they wanted to leave the option open to say, hey, we didn't say Congress doesn't have the power. We said when Congress uses this power, it's so rare and so broad that it should be exercised very clearly.
Okay.
And there were some statutes in the CMS case applicable to many of the providers that did say that CMS has the authority to impose infection control measures on those providers.
Okay.
And vaccination is an infection control measure. So I think they were trying to leave their options open for future cases.
Yeah.
Because it's, none of us can see the future. We don't know what we can't imagine happening. And so you leave your options open. I think that explains their votes.
So is there likely – so what happens from a legal perspective here, Pepper, is now that the private sector mandate's been struck down at the highest court in the land, can it resurface? I mean, can it come back up? Can there be an appeal? How does that work?
Well, I don't think OSHA can just recast it as a final rule under the Administrative Procedure Act and pass muster. I think Supreme Court has foreclosed that option. Could they wait months or a year and then amidst a new surge come up with some new rule that they run through the Administrative Procedure Act instead of as an emergency temporary standard and get a wholly new kind of review? I think that's possible. I think they've learned a lot and would probably do things differently. They would probably have not one rule, but several rules applicable to different kinds of industries, more narrowly focused. I think that's not out of the question. They could do that.
So, once again, but an employer, they just got to carry on with business. So let me ask you this question. I saw this morning where Nike fired, I don't know the number, but it was, I want to say it was like 170 is the number that comes to mind. But they fired a number of their employees because of an internal policy that requires employees to be vaccinated. They just went, this is not because of any federal mandates or federal regulations, just on their own accord as a private company. Are they within their right to do that?
Well, it would depend on state law and whether or not those employees have contracts, either individual contracts or union contracts that might have something to say about that.
Okay.
But assuming there's no state law impediment and there's no contract provision that limits the employer's authority, yes, the employer can do that. And, because of the condition of the economy, those employees who want to work will have jobs tomorrow. Everybody I know is begging for labor.
Yeah. It's just from the practical perspective, from an economic perspective, it just doesn't sound like the smart thing to do. I've even read reports that there are some hospitals that are now allowing their infected employees, due to the shortage of healthcare workers, to work at the facility, but they're only allowed to interact with infected patients. So it's infected healthcare workers that are servicing and caring for infected patients.
It's not just, I have great sympathy for healthcare providers, but it's not just healthcare providers. It's other people who are performing absolutely essential functions who are faced with only bad choices they can make. And I am not going to be one who criticizes folks who have no good choices available to them. Yeah,
and that's what's going on here. So I've thought from the beginning, look, the market will sort this thing out. If companies put those requirements in place and they can't staff their company in a way that allows them to produce the profit they need to maintain, well, then they'll make adjustments or they'll go out of business, essentially. The market has an interesting way of kind of curing those situations.
It's not just the companies that are in business. It's us consumers. Would you like to see bread on your shelf when you go to the grocery?
Yeah.
Well, you need a truck driver. You need somebody baking the bread.
Absolutely good point. Yeah. So should the state of Mississippi, and maybe this is an unfair question to get your opinion on this, but should the state of Mississippi, should it look at passing a law that would prohibit a private sector company from instituting a mandate such as this, a vaccination mandate?
Speaking for none of my clients and for no organization with which I'm affiliated, I think that would probably be a bad idea. One of the things the Mississippi government has been pretty consistent about is trying not to regulate conditions of employment except at the far margins. where things are really out of control and really have an adverse public effect. I suspect that would not go down well in the legislature.
Yeah. Well, I know there's members of the citizens of the state of Mississippi I've seen that have actually held rallies, for such an effort, calling on state leaders and legislators to pass a law that would, and there are members of the legislature that I know that favor this. My concern is, what's next? What next are you going to throw at us, private sector employers, that is just meets your whims, I guess, in that respect. So that can be as egregious, even though I understand the noble, the virtuous aspect of it, is something else you may think. We just want these employers to do this. That's over-regulation from government, in my view. Let the private sector and the market work that out.
There's never been a better time to be a fired employee.
No question about it.
Never.
That's a good point. From a personal perspective in your profession, is your phone ringing off the wall dealing with this matter? Just got to ask you.
No.
No.
No. And here's why. I am the one who's communicating to my clients. I have regular Zoom sessions with my clients.
Okay.
And so my phone's not ringing because they're hearing from me several times a week.
You're proactive.
Yes.
And you always have been.
Yeah,
so.
Yes. And the other thing, the reason I'm not hearing a lot from my clients is the people who keep people like me busy, the people who mess up at work, get fired, blame their employer and sue, they're not working right now.
That's a good point.
That's right. Your core employees who you depend on, who are responsible, conscientious, will drive through snow and ice to get to work because that's just how they're wired. Those are the people who are working. They don't mess up.
They don't cause any problems. I never thought about that. That is an excellent point. But now that you mention it, as an employer, I get that. Thank God I didn't have that much of that.
You know
in my
who those
career.
people are.
I absolutely do.
Yeah.
Interesting. Well, I hadn't thought about that. So, one thing, though, that this has done, it would seem, in your line of work and your practice area, is it's just kind of introduced just a whole new subject matter to it. Is that fair to say?
Yes. Well, when I started this back in 1982, what I considered overreaching federal regulation wouldn't get noticed today.
If I can see that, boy, if we ever come a long way.
Boy. Yeah.
And no question, because those bureaucrats, that's what they do. They make laws, and then that drives promulgation of rules and regulations.
The ratchet only turns one way, and it just never stops turning.
It doesn't go the other way.
Right.
It's almost like, well, we reduced our budget. No, you just reduced the increase in the budget. We reduced regulations. No, you pared down the amount of new regulations.
One of the biggest educations in my career has been when I started reading the Federal Register every morning, starting in June 2014 when the NFIB versus Sebelius ACA decision came down.
Yeah.
My eyes were open to how much our government thinks it has the competence and resources to regulate and how ridiculous that idea is. You just wouldn't believe. I found out yesterday, until yesterday, our government had a federal rule on French dressing.
Huh?
Yeah. What can call itself French dressing? There's a lobbying association that prevailed on a federal agency to create a rule on what is French dressing.
You got to be kidding me.
And there are thousands and thousands of more rules that are that silly. Yeah.
And somebody, a lot of folks are getting paid and making a living off chasing stuff like that, and buying lots of steak dinners for lawmakers, members of Congress, to put stuff like that in laws and bills.
Who was the Mississippi legislator? This is probably back in the 70s. Who was answered a question about what's it take to pass a bill. He said lots and lots of whiskey and crustaceans.
Crustaceans. Yeah, I think it's beef now. Of course, that's getting pretty expensive. So anyhow, appreciate, as always, Pepper, the insight and the information there. That was quite valuable. Hope our audience enjoyed it as much as I did. And we'll, I'm sure, be talking to you more and talking to you soon about this. Pepper Crutcher, attorney, Balsha Bingham, has been talking to us about the vaccine mandates and the Supreme Court's